name is Tara Mooney. I'm an immigration attorney in New York City, and I work for Gavlin and Associates. Today I'd like to talk to you about a form of relief from removal called cancellation of removal. There are several ways you would be eligible for cancellation of removal, and there are various reasons you might be placed into removal proceedings because of your immigration status, mostly because you would have a criminal conviction on your record. The first form of cancellation of removal I want to talk to you about is for people who already have lawful permanent resident status, which means you already have a green card. In order to qualify for this form of relief, you would need to have resided in the United States for at least 7 years in any status, not necessarily holding a green card. The second qualification is that you do need to have a green card for at least 5 years. And the third requirement is that you cannot have committed an aggravated felony. The list of aggravated felonies is quite extensive. It can include anything from any sort of drug trafficking to a theft offense to a firearms conviction. You would definitely want to consult an attorney to find out whether or not your conviction constitutes an aggravated felony. Furthermore, your criminal attorney should advise you as to whether or not whatever you are pleading to or whatever you have been convicted of is an aggravated felony. The second form I would like to talk about is cancellation of removal for non-permanent residents. This category is a little more complicated because obviously you haven't been holding a green card, so they're going to be strict with you. The requirements for this are that you have to have resided in the United States for at least 10 years. You have to show good moral character, meaning that you haven't been arrested. You would need letters of support from relatives, from any employer that you've been with, and you would also have to show that your removal from the United States would show extreme hardship to a qualifying relative. Finally, the last form of cancellation of removal, if you are placed in removal proceedings, is under the Violence Against Women Act, and this applies to both men and women. And this is for anyone who was physically or mentally or emotionally abused by their spouse. The basic requirements are that you have to have been in the U.S. for at least 3 years. You have to be married or recently divorced from a U.S. citizen or lawful permanent resident. And you have to show proof that you have lived with your spouse in the United States. This basically helps people who are married to someone and their spouse is threatening them because they won't help sponsor them for a green card This helps people who have been in the United States but have been married to a United States citizen or lawful permanent resident and have been physically, mentally, or emotionally abused by this person. They can basically self-apply for a green card through the court system. This part is more difficult. You have to have been in the United States for at least 3 years. You have to show proof of your marriage, and you have to show proof that you lived with your spouse. This situation usually happens in cases where the spouse has abused you and you don't have any other recourse for immigration relief. This process is confidential. It goes through the court, and you never have to tell your spouse or anybody else about this. Cancellation of removal is a defensive form of relief in immigration court, which you may not even realize that you need if you're going through the criminal process. You should always consult with your criminal attorney and an immigration attorney before you plead to anything or before you go through a trial. because even if something is not considered a felony in criminal court, it can be considered an aggravated felony in immigration court, and that would lead to being placed in removal proceedings. Even if you meet the requirements for any of the categories I've mentioned above, you can still apply for cancellation of removal even if you have not been placed in removal proceedings by going to an immigration attorney. They can help you to get in front of a judge and have your case heard. Again, my name is Tara Mooney, and I'm an immigration attorney in New York for Gavlin and Associates, and if you have any further questions, you can contact us or any other office, and we'll be very happy to help you. Thank you.